Suppose Parliament passes an excellent law today. Will it automatically reach the people tomorrow? Suppose it allocates 10,000 crore for healthcare. Will hospitals automatically improve? And suppose it guarantees free education. Will every child automatically receive quality education? Certainly not. Who converts laws into reality? Who converts laws into reality? That is the executive, the administrative engine of the Indian state, not just a list of constitutional offices. That is the executive. The executive is much larger than politicians. It includes the president, the prime minister, the council of ministers, the cabinet, governors, chief ministers, civil servants, administrative departments, and thousands of public institutions working every day. Whenever you receive a passport, whenever a vaccination program reaches a village, whenever roads are built or disaster relief arrives, the executive is working. The executive is working. It is the face of the state that citizens interact with every day. That is called as the executive or executive. Why did the constitution create a separate executive? Could parliament itself implement laws? But practically no. Why? It meets for limited periods and its primary role is legislation, deliberation, and accountability. That is the role of parliament. Then implementation requires a permanent administrative machinery. Permanent administrative machinery that converts policies into programs, budgets into expenditure, laws into rules, rules into public services. That is why every modern democracy separates lawmaking from law implementation. That is why separation is need of the hour from lawmaking to law implementation. At the union level, president is the constitutional head of the executive. At union level, president is the constitutional head of the executive. But India follows the parliamentary system. So real executive authority is exercised with through the council of ministers headed by the prime minister. This is real executive authority, political leadership. Because democratic accountability requires that those exercising executive power remain responsible to the elected house of the people. So constitutional head of the executive is president, but real executive authority, that is the political leadership and a council of ministers headed by the prime minister. Because this because democratic accountability requires that those exercising executive power remain responsibility remain responsible to the elected house of the people. So the constitution distinguish between formal authority and effective authority. Constitution distinguish between formal authority and effective authority. The president represents constitutional continuity. The prime minister provides political leadership, and the council of ministers collectively exercise executive power. and civil servants ensure administrative continuity. So authority is distributed, responsibility is shared, and accountability is maintained. That is the constitutional design. Comes to the cabinet, and the cabinet, every cabinet minister is part of the council of ministers, but not every minister is part of the cabinet. Every cabinet minister is part of the council of ministers, but not every minister is part of the cabinet, because modern governance requires quick decision making on national security, economic policy, disaster response, foreign affairs, budgetary decisions. The cabinet becomes the principal decision making body, coordinating governance across ministries and converting political parties into governmental action. So the executive functions through specialized ministries and departments such as health, education, agriculture, finance, defense, external affairs, electronics and information technology, women and child development. Because modern administration is too complex for any single institution to manage every sector. Comes to the cabinet again. Every cabinet minister is in the council of ministers, but not every minister is in the cabinet. Principal decision making body comes to the national security, economic policy, disaster response, and executive accountability flows through parliament, judiciary, comptroller and auditor general, RTI, vigilance bodies. And political executive sets direction, but permanent executive, that is civil services, delivers continuity. So executive accountability matters because power without accountability is dangerous. The executive remains accountable. The executive the executive remains accountable through parliament, the judiciary, and controller and auditor general, central vigilance institutions, information commissions, parliamentary committees, media, civil society, and citizens through the RTI, Right to Information Act. The constitution never assumes power will always be exercised perfectly. It creates institutions that continuously review executive action. So today's executive manages digital governance, artificial intelligence, cyber security, climate change, public health, disaster management, space technology, digital payments, data protection, national security, and global supply chains. So governance has become multidimensional, requiring coordination, technology, specialization, intergovernmental cooperation, and evidence-based policy making. So today's executive manages digital governance, artificial intelligence, cyber security, climate change, public health, disaster management, space technology, digital payments, data protection, national security, and global supply chains. And governance has become multidimensional, requiring coordination, technology, specialization, intergovernmental cooperation, and evidence based policy making. Comes to the one important relationship in political executive, provides policy direction, while the permanent executive, that is the civil services, provides administrative continuity. So governments change, civil services remain. A civil servant must faithfully implement the policies of the elected government while remaining constitutionally neutral and professionally impartial. That balance is essential for a democratic governance. That is the relationship between political executive and policy direction and the permanent executive. Comes to the answer writing. Suppose UPSC asks, the effectiveness of the executive depends not merely on constitutional powers, but on institutional accountability and administrative capacity. Discuss. This is the question. The effectiveness of the executive depends not merely on constitutional powers, but on institutional accountability and administrative capacity. Discuss. A high scoring answer explains what to do, explains the constitutional, explain the constitutional role of executive in the first sentence, in the first instance. Then distinguish the nominal executive from the real executive. Nominal executive, president, real executive, council of ministers headed by prime minister. Then analyze implementation capacity, coordination and professionalism. Then evaluate challenges, comes to the centralization, coordination gaps, etc. Then after, suggest practical governance focused reforms, comes to the way forward in the form of. So this is the way of the answer writing, from explaining the constitutional role to suggest practical and governance focused reforms. This is the way how to you have to write an answer. The constitutional role of executive, distinguish the nominal and nominal from the real executive, analyzes implementation capacity, coordination professionalism, technology and citizen centric governance, evaluates challenges like centralization and coordination gaps, and suggests practical reforms. It analyzes governance, not just institutions. That is the way you have to write an answer. So let us summarize. The executive is the constitutional machinery through which the state acts. The executive is the constitutional machinery through which the state acts. Parliament gives legal authority. The executive gives it administrative life. Without an effective executive, laws remain words, budget remains numbers, policies remains promises. So the union executive we have just studied, however, is only the apex of much larger administrative structure that extends downward through the states and finally to the citizens' doorstep. That takes us to the local government. That is the third and closest tier of the Indian state. That is the local government. Democracy at the doorstep. We have studied the union executive and briefly the states. But think about this, when a street light breaks, when a drain overflows, when a ration card needs correction, does a citizen approach the prime minister? Does a citizen approach the chief minister? Of course not. They approach the gram panchayat or the municipal corporation. That is local government, the third tier of Indian federalism. and the level of the state closest to the citizen's actual life. For nearly 4 decades after independence, local government existed, but weakly dependent entirely on state governments for its existence, powers, and even survival. A state could dissolve a panchayat whenever it wished. There were no guaranteed elections, no guaranteed funds, and no guaranteed functions. The local government was present on paper but not empowered in practice. Before 1992, weak discretionary, no guarantees. That changed with the 73rd and 74th constitutional amendments in 1992. One of the most significant and most under revised reforms in the Indian constitutional history. The 73rd Amendment gave constitutional status to Panchayati Raj institutions in rural India. And the 74th Constitutional Amendment did the same for urban local bodies, that is, municipal corporations, municipal councils, and Nagar Panchayats, etc. For the first time, local government was no longer a state's discretionary gift. It became a constitutional guarantee. So, what exactly did these amendments guarantee? These amendments guarantee three things, and UPSC loves asking about exactly these three. The first one is mandatory elections every 5 years, conducted by an independent state election commission, insulating local democracy from political convenience. And second one, reservation for scheduled castes and scheduled tribes and women. At least one third of seats reserved for women. And extending the principle of representation all the way down to the village level. And third one, the creation of state finance commissions tasked with recommending how financial resources should devolve from the state to local bodies, mirroring at the state level exactly what the Union Finance Commission does at the national level. These three things. And here is where UPSC real interest lies, not in the existence of these institutions, but in whether they actually work. The Constitution speaks of devolution of what are called the three F's. What are the three F's? Funds, functions, and functionaries. On paper, the 11th and 12th schedules or 12th schedules list subjects meant for panchayats and municipalities like agriculture, education, health, sanitation, poverty alleviation, etc. In practice, most states have devolved functions without devolving adequate funds or trained functionaries to match. So, a panchayati may be constitutionally responsible for primary health care, but if it has neither the budget nor the staff, that responsibility remains symbolic. So, that is why devolution is important. This is exactly why local government sits inside the larger conversation of on federalism that we studied earlier. Funds, functions, and functionaries. It is not a separate topic. It is federalism's third and most incomplete layer. Cooperative federalism is usually discussed centers to state, but UPSC increasingly expects you to extend the same lenses state to local government. So state finance commissions recommended resource sharing, but transfer are often delayed or diluted. And 11th and 12th schedules assign 29 plus 18 subjects, but many stay only on paper. Local bodies need trained staff to deliver, and most states under resource quietly. So these three funds, functionary, and functions are incomplete. That is why devolution remains incomplete. Comes to the answer writing part. Suppose UPSC asks local self-government. UPSC asks local self-government has acquired constitutional status, but not administrative and financial autonomy. Discuss. The answer should be like this. In the first instances, you have to explain the pre-1992 weakness, then the constitutional guarantees introduced by the 73rd and 74th Amendments, then 3F's devolution framework, then evidence of uneven implementation across states, and the reforms strengthening state finance commission, then capacity building for elected local representatives and a genuine functional devolution. This is the answer writing approach. So let us summarize. Local government is where the constitution promises of democracy is tested most directly, not in parliament's debates, but in whether a village panchayat can actually build a road. Constitutional status was the first step. Functional empowerment remains the unfinished one. Within this multi-tier structure, one constitutional office sits awkwardly between the union and the state, holding both political neutrality and a real discretionary power. That office is the governor. We are going to discuss in detail. Within the executive, one office deserves separate attention because it sits at a genuinely awkward constitutional position, not fully of the union, not fully of the state. That office is the governor, office of the governor between the union and the states. Why does a state even need a governor when it already has an elected chief minister? Why? Because the governor is not meant to govern in the political sense. The governor is the constitutional head of the state, appointed by the president, meant to be a link between the union and the state, and a custodian of constitutional propriety at the state level. In the same way, the president performs that role nationally. In normal functioning, the governor acts as the aid and advice of the state council of ministers, exactly as the president does at the union level. So, but unlike the president, the governor possesses certain discretionary powers. And this is precisely where UPSC's interest concentrates. What exactly the discretionary powers? Reserving a bill for the president's consideration and recommending president's rule under Article 360, 356, and most contested of all, the exercise of discretion in appointing a chief minister after a hung assembly or deciding when to test government's majority on the floor of the house. These discretionary powers where UPSC focuses, like reserving a bill for the president's consideration and recommending president's rule under 356 and appointing a CM or chief minister after a hung assembly and timing floor tests. Why does this generate recurring controversy in frequent days? Because discretion, by definition, cannot be fully codified. In a hung assembly, who should the governor invite first? Who should governor invite first? The single largest party or a post-poll alliance claiming a majority? The constitution does not spell out a rigid formula. That is the main problem here. That is the main problem lies here. Conventions and Supreme Court guidance have filled that gap over a period of time, particularly following cases that required floor tests to be conducted promptly and transparently rather than allowing indefinite discretion. Governor hung assembly floor test and Supreme Court review and majority proven. Conventions, these are. So contemporary friction around this office is real and recurring. Why? Delays in granting assent to state bills, tension between governors and state governments of a different political party than the union, and debates over the appropriate limits of gubernatorial discretion. Gubernatorial discretion. UPSC does not want you to take a political side here. It wants you to evaluate the constitutional design, why discretion exists, and why it is necessary in a parliamentary system, and why it must still operate within recognizable constitutional limits. That is here UPSC wants you to examine again and again. They need constitutional design. They expected from you regarding constitutional side rather than political side. So comes to the answer writing part. Suppose UPSC asks, the office of the governor was designed. Currently, office of the governor is most trending and important topic for UPSC mains 2026. So for this answer writing, suppose UPSC asks like this. The office of the governor was designed as a constitutional link but has increasingly become a source of center state friction. Discuss. This is the question. How to write an answer? A topper or a high scoring answer like this explains the constitutional design and intended role of the governor. Then distinguishes discretionary from non-discretionary functions of the governor. Then discusses relevant judicial guidance on floor tests and gubernatorial discretion, and evaluates contemporary center state tensions, and suggests reforms such as a fixed timelines for granting assent and clearer conventions on government formation. So in the SR Bommai versus Union of India 1994, the court said the governor's assessment is not final. A government's majority can only be tested where the constitution says it must, on the floor of the house only, rather than governor's Raj Bhavan or Lok Bhavan. So the floor of the house, government's majority has to be proven. This is the same discipline that reshaped Article 356. So let us summarize. The governor is not meant to be a political actor. The office of the governor was designed as a constitutional bridge. Whether it functions as a bridge or as a fault line depends less on the constitution's text and more on how the discretion is actually exercised. Rather than text, it's depend on action. So the governor's discretionary powers, as we just saw, become most consequential exactly when a state's constitutional machinery is under stress. That takes us to the broader constitutional design for moments of crisis, that is, the emergency provisions. Comes to the emergency provisions when the constitution under stress. So everything we have studied so far assumes normal constitutional functioning, like elections happen, legislatures meet, governments are accountable, etc. etc. But what happens when normal functioning itself breaks down, like war, internal breakdown of constitutional machinery, or a threat to India's financial stability? In that time, what will happen? The framers anticipated this and built in emergency provisions. That is a constitutional design for abnormal times. So, why would a constitution built on federalism and rights deliberately create provisions that concentrate power? Why? Because the framers had lived through partition and understood that a democracy that cannot survive a genuine crisis is not much of a democracy at all. So they built three distinct types of emergency, each responding to a different kind of threat and each with different triggers and different safeguards. Those are national emergency and president's rule and financial emergency. The national emergency under Article 352 may be declared when the security of India or any part of it is threatened by a war, external aggression, or armed rebellion. Notice that internal disturbance, the original and more easily misused trigger, was replaced with armed rebellion after the experience of 1975, precisely to prevent misuse. That is why change it to armed rebellion. During a national emergency, the federal structure tilts sharply toward the union. The center can legislate on state subjects and several fundamental rights, though notably not Articles 20 and 21, may be suspended in their enforcement. Rights suspended except Article 20 and 21. So comes to the Article 356, that is President's rule, applies when a state's constitutional machinery breaks down. When a state government can no longer be carried on in accordance with the constitution. This is where the governor's recommendation we just discussed becomes directly relevant. Article 356 has historically been the most controversial emergency provision, repeatedly used in the Supreme Court's own words, repeatedly used in the Supreme Court own words in Bommai case for reasons that were more political than constitutional. That judgment established that the exercise of Article 356 is subject to judicial review. Subject to judicial review. So, and that a government's majority must be tested on the floor of the assembly, not assumed by the governor. This single judgment did more to discipline the use of Article 356 than the constitutional text itself. So, this is the constitutional machinery breakdown in a state. So, comes to the financial emergency under Article 360, addresses a threat to India's financial stability or credit, and remains notably a provision that has never actually been invoked in India's constitutional history. Thanks to the Indian economy system, financial system, UPSC occasionally tests exactly this fact because students to assume all three emergency provisions have been used only to have used till now. No financial emergency takes place till now. Why does this topic matter so much for GS2? Beyond memorizing articles, because emergency provisions are the clearest test of the basic structure doctrine in practice. Can concentrated power over become permanent under the guise of an emergency? No, it's not. The 44th Amendment introduced precisely because of the 1975 experience built in safeguards, parliamentary approval within 1 month, periodical renewal, written cabinet advice required before a national emergency can be proclaimed, and the redefined trigger of armed rebellion. These safeguards exist because India actually tested the limits of emergency power once and rewrote the rules afterward. Comes to the 44th Amendment safeguard. The 44th Amendment safeguard introduced after 1975. What it introduced actually? What it introduced actually? Parliamentary approval within 1 month, periodic renewal, written cabinet advice, and armed rebellion replacing the easily misused internal disturbance. This is comes with the safeguard from the 44th Amendment Act. For answer writing, suppose UPSC asks like this: emergency provisions reflect an inherent tension between the need for a strong union in crisis and the protection of federal and individual rights. Discuss. What you have to write an answer for this high scoring. Explains the constitutional rationale for each type of emergency. Discuss the 1975 experience and its impact on subsequent safeguards, and analyze the Bommai judgment's role in disciplining Article 356, and evaluates whether current safeguards sufficiently balance national security with federal and rights protections. So this is the way of the answer writing. First and foremost, I repeating the question again. Emergency provisions reflect an inherent tensions between the need for a strong union in crisis and the protection of federal and individual rights. Discuss. A high scoring answer explains like this: the constitutional rationale for each type of emergency. Discusses the 1975 experience and its impact on subsequent safeguards, and analyze the Bommai's judgment's role in disciplining Article 356, and evaluates whether current safeguards sufficiently balance national security with federal and rights protections. So let us summarize. Emergency provisions are not a contradiction of constitutional democracy. They are democracy's answer to the question, what happens when things go wrong? Their history teaches a larger lesson we have returned to throughout this chapter, like constitutional power, however necessary, must always remain countable, reviewable, and temporary. Every one of these emergency powers, no matter how necessary, raises the same underlying question we have returned to throughout this chapter. Who ensures that power, however concentrated, however well intentioned, remains within the constitutional limits? That responsibility belongs to the judiciary. That is the constitutional guardian of democracy. That is the judiciary. Till now, we discussed executive, local government, governor, and emergency provisions. Comes to the emergency provisions, we have three types of emergencies. Under Article 352, national emergency. Under Article 356, constitutional emergency or president's rule. And 360 article, that is financial emergency. So the executive, formal versus effective authority. Comes to the formal, president, and effective authority comes to the prime minister. The cabinet as the engine, council of ministers headed by the prime minister. And comes to the local government, 73rd and 74th amendments. Before 1992, the local government was weak. From 73rd and 74th amendment, it takes as constitutional status. The unfinished three F's, funds, functions, and functionaries. So comes to the governor. Governor is const- constitutional discretionary powers and disciplined by Bommai. Discretionary powers, certainly tensions, frictions between state government and governor. And then comes to the emergency provision, Article 352, 356, 360. And then 44th Amendment safeguards, that is. And one and most one takeaway, that is constitutional power must stay accountable, reviewable, and that too temporary. Then comes to the next chapter, that is the judiciary, the guardian of the constitution. We have traveled through the constitution, federalism, parliament, state legislatures, elections, pressure groups, the executive, local government, the governor, and emergency provisions. These discussed so far. Now, suppose Parliament passes a law and the executive implements it. Who ensures both remain within constitutional limits? Who protects citizen rights and resolves disputes between governments and interprets the constitution when disagreements arise? Think once. Who's that? The judiciary. The judiciary does not govern India. It does not make policies and administer districts or contest elections. Then why is it one of the most powerful institutions in a constitutional democracy? Because it performs one responsibility no other institution can. That is, it protects the constitution. It protects the constitution. Imagine Parliament passes a law abolishing freedom of speech, or the executive arrests citizens without due process, or two states disputes constitutional powers. Who should decide? Who should decide? Not Parliament. It is itself a potential party to the dispute, not the executive. For the same reason, a constitutional democracy needs an independent institution to interpret the constitution impartially. So remember this very carefully. The judiciary is not above the constitution. It exists to keep everyone under the constitution. Under the constitution. So why is judicial independence so important? It is not a privilege given to judges. It is a protection given to citizens. If judges become dependent on government, can they fairly decide cases against it? The Constitution provides safeguards, security of tenure, fixed service conditions, a rigorous removal process, financial independence, institutional autonomy, not for individual judges, but to preserve public confidence in constitutional justice. That is why judicial independence is in the need of the hour. That is the thing. So that is why every GS2 question on the judiciary comes back to four functions. What are the functions? That is first and foremost function is constitutional interpretation. The constitution cannot anticipate every future situation like artificial intelligence, digital privacy, environmental rights, data protection, genetic technology, etc. The judiciary continuously interprets constitutional principles to keep them relevant. That is the thing here. Then comes to the protection of fundamental rights. Rights are meaningful only when citizens can enforce them. Rights are meaningful only when citizens can enforce them. Dr. B.R. Ambedkar described Article 32 as the heart and soul of the Constitution. So, rights without remedies are only ideals. The judiciary transforms them into enforceable protections. That is the Article 32. So, comes to the judicial review part. The judiciary examines whether laws and executive actions conforms to the Constitution. It is constitutional or unconstitutional. It is review. It will be review. It never asks, is this policy politically popular? Only is this policy constitutionally valid or not? That's it. The Constitution remains the standard, not political convenience. So then comes to the fourth one, dispute resolution. So dispute resolution, center versus state, state versus state. So citizens versus government, election and administrative disputes. The judiciary acts as the constitutional resolving disagreements through legal reasoning rather than political power. So the judiciary has four constitutional functions. That is constitutional interpretation and protection of fundamental rights and judicial review and dispute resolution. And judicial activism and restraint, commonly misunderstood terms. That is, activism does not simply mean courts are active. Then what? It refers to an expansive interpretation of constitutional responsibilities, especially to protect rights or address governance failures, like public interest litigation being one of the examples. So comes to the restraint part. Restraint reminds court to respect the constitutional boundaries of other institutions. The judiciary cannot permanently replace the legislature or executive. This balance reflects the principle of separation of powers. So contemporary challenges include pendency of cases, vacancies, access to justice, litigation costs, infrastructure, technology adoption, transparency, appointment process, and balancing independence with accountability. So UPSC rarely asks what is the collegium system. It asks critically examine the challenges associated with judicial appointments or discuss reforms necessary to improve access to justice. The emphasis always on analysis. analysis. So these are the contemporary challenges like pendency of cases, vacancies, access to justice, appointment transparency, etc. So digital evidence, cybercrime, artificial intelligence, online platforms, data privacy, climate litigation, electoral transparency, technology has transformed governance, and the judiciary continuously interprets constitutional principles in new contexts. So the constitution remains the same, the situation evolves. So comes to the answer writing part. Suppose UPSC asks like this: an independent judiciary is indispensable for constitutional democracy, but judicial accountability is equally important. Discuss. Comes to the answer part. Why judicial independence is essential for constitutional supremacy? You have to explain. Then explains judicial review, then rights protection and interpretation, then evaluates concerns around appointments, then comes to the transparency, delays and access to justice, and suggests balanced reforms. It evaluates the institution rather than merely describing it. So what you have to do is first explains, first you have to write, establishes why judicial independence is essential for constitutional supremacy. You have to write that point, write that part. Then explains judicial review, rights protection and interpretation, then evaluates concerns around appointments, transparency, delays and access to justice, and suggested balanced reforms. It evaluates the institution rather than merely describing it. So let us summarize. The judiciary is the constitutional guardian of the republic to protect rights, interpreting the constitution, resolving disputes, reviewing public power, and preserving constitutional supremacy. These functions, without an independent judiciary, democracy becomes vulnerable. With one constitutional government remains secure. So, till now we discussed so far the judiciary part, four constitutional functions: interpretation, rights protection, review, and dispute resolution. And judicial activism and restraint part, bill expansion, separation of powers. And the contemporary challenges, pendency of cases, appointments, access to justice, etc. The judiciary exists to keep everyone under the constitution. That is the one takeaway you have to take. Then now let us move to another set of institutions that quietly sustain constitutional governance every day: the constitutional, statutory, regulatory, and quasi-judicial bodies. We have studied the three great organs of the state till now, that is the legislature, the executive, the judiciary. So why did India create so many other institutions rather than three, like the election commission, the finance commission, the COG, the UPSC, the NHRC, the CIC, and the Competition Commission of India, the Lokpal, etc., etc.? Could Parliament or the government not perform all these functions themselves? The answer is no. And understanding why is the key to this entire topic. So every day in a country like India, millions of decisions are taken: taxes collected, elections conducted, recruitment carried out, public money spent, information sought, markets regulated, human rights protected, environmental standards enforced. Can one institution perform all of this? Just think once. Possible. Modern governance has become far too complex. So democracies create specialized institutions not because they want more bureaucracy, but because they want better governance. That is the thing here, better governance. Suppose the government itself conducted elections, would political parties trust the result? Trust the result. Suppose it audited its own expenditure, would that inspire confidence? Suppose it recruited civil servants entirely on its own discretion, would citizens believe the process is fair? Certain functions must remain insulated from the day to day political influence. That is the constitutional philosophy behind these institutions. So comes to the constitutional bodies part. Derive their authority directly from the constitution because their functions, free and fair elections, independent recruitment, financial accountability, distribution of resources, protection of constitutional values are considered to fundamental to depend on the changing preferences of ordinary governments. That is why constitutional bodies insulated by design. So comes to the constitutional bodies. The first body is election commission. The election commission protects electoral legitimacy. Without credible elections, democracy loses its moral authority. It represents the constitutional process, not any political party, not any political party. It is day-to-day conduct of elections, as we saw earlier, is carried out through the framework of the Representation of People Act from 1950 and 1951. So this is the election commission. Election commission protects electoral legitimacy, the constitutional process, not any political party. Then comes to the controller and auditor general. So the controller and auditor general of India verifies whether public money has been spent lawfully and efficiently. This is the first and foremost of primary thing. It does not merely audit accounts, it strengthens financial accountability, ensuring every rupee collected from citizens remains publicly accountable. This is verifies lawful, efficient spending of every public rupee. Then comes to the Finance Commission. The Finance Commission addresses a federal challenge. Resources are unevenly distributed across India, but development must remain balanced. It recommends how financial resources should be shared between the union and the states, as much a federal institution as an economic one. So that is why Finance Commission is most important. Comes to the Union Public Service Commission. It protects merit in public recruitment. Government and political parties may change, but the civil services require professional competence and the administrative neutrality. Recruitment based on merit, not political preference. Every one of you preparing today is doing so through a constitutional institution, which itself demonstrates why institutional independence matters. Here, merit based recruitment against political preferences. That is UPSC. Then comes to the statutory bodies. Unlike constitutional bodies are created, unlike constitutional bodies, statutory bodies are created through acts of parliament because governance continuously evolves and the constitution cannot anticipate every future institution. That is why statutory bodies evolved, like human rights, transparency, anti-corruption, women's rights, environmental protection, minority rights, technology, as these challenges expanded over time. Parliament created bodies like NHRC, National Human Rights Commission, Central Information Commission, Lokpal, National Commission of Women, National Commission for Women, and the National Commission for Protection of Child Rights, etc. Then comes to the regulatory bodies. Regulatory bodies exist because modern economies cannot function without regulation, like competition, telecommunications, electricity, securities market, insurance, banking, digital platforms, and artificial intelligence. These sectors needs continuous technical supervision that neither parliament nor ministries can provide daily. So independent regulators create stability, predictability, investor confidence, consumer protection, and fair confidence. Fair competition, like Competitive Commission of India, Telecom Regulation Authority of India, Security Exchange Board of India, etc. etc. Then comes to the quasi-judicial bodies, exists because not every dispute requires a regular court, like taxation, competition, consumer protection, environment, service matters, etc. etc. These need specialized expertise. So institutions like administrative tribunals combine legal procedure with technical knowledge. So knowledge, reducing the burden on regular courts and improving administrative efficiency. Comes to the administrative tribunals with law expertise. These are quasi-judicial bodies like taxation, competition, consumer protection, etc. Whenever UPSC asks about these institutions, it rarely asks what is the election commission. It asks discuss the challenges faced by constitutional institutions or evaluate the role of independent institutions in strengthening democratic accountability. So it is evaluating institutional performance, not institutional description. So as governance challenges around artificial intelligence, digital privacy, platform regulation, climate governance, cyber security, data protection, and fintech become increasingly specialized. Institutional capacity, independence, transparency, and accountability will only grow more important, which is why UPSC increasingly asks analytical questions on institutional reforms. So comes to the answer writing practice. Suppose UPSC asks independent institution. Suppose UPSC asks one question like this: independent institutions are indispensable for constitutional democracy, but institutional independence must be balanced with accountability. Discuss. Identify the first and foremost, identify the constitutional problem or question being tested. Then explain the concept, its origin, purpose, and evolution. Then analyze its contribution to constitutional democracy. Then evaluate criticisms or contemporary challenges even handedly. Then conclude with a balanced observation or practical reform. This is the way of the writing an answer. Constitutional demo have to explain why constitutional democracies require specialized institutions, then analyzes how they strengthen electoral integrity, then financial accountability, then administrative neutrality and transparency, then evaluates challenges around appointments, then resources, political pressures and capacity constraints, and suggests reforms that strengthen both independence and accountability. It explains institutional philosophy, not just institutional facts. So let us summarize. Constitutional democracy cannot survive merely through parliament, the executive, and the judiciary. Modern governance requires specialized institutions, some protecting elections, some protecting public finance, some protecting merit, some protecting human rights, some regulating markets, some resolving specialized disputes. Together, they create a system whether power is exercised, reviewed, regulated, and continuously held accountable. That is the true architecture of institutional governance. So comes to this part, we discussed so far constitutional philosophy with the five pillars and eight salient features. Then comes to the basic structure, the tree that parliament cannot approve, that is Keshavananda Bharati case. Then comes to the federalism, three lists, cooperative platform, and real changes. Then comes to parliament and representation, then state legislature, RPA, and pressure groups, and then comes to the executive part, local government, and 73rd and 74th Amendment Act, the governor, friction, emergency provisions. Then comes to the judiciary part, four constitutional functions, activism versus restraint, PIL, judicial review, and comes to the institutional bodies. It comes to the institutional bodies, constitutional bodies, statutory bodies, regulatory, and quasi-judicial bodies. Different questions, same constitutional philosophy, prepare principles, not just provisions. So till now we discussed from constitutional philosophy to basic structure to federalism, then parliament, state legislatures, representation, the executive, the judiciary, and the institutional bodies. Then we are going to discuss social justice and international relations, etc. Thank you.